A lot of people think that the Ninth Circuit Court of Appeals is the most anti gun circuit court in the country, but they would be wrong. That is the fourth. And we have a decision out of the fourth that just proves that spectacularly. What's up, everyone? This is John Crump. And before I get into today's story, I've had a lot of people ask me why I'm not covering the tragedy that happened in Minnesota. And just wanted to state my whole entire thing on that. If you haven't heard it, you're going to hear it now. I do not believe on reporting on those types of issues because most of the people that carry out those types of events, they just want the notoriety, and I will not give them the notoriety that they so desperately seek. So, with that said, let's go ahead and jump into the case we're talking about today. And this case is near me, and it is LaFave versus the County of Fairfax. I live in Loudoun County, which is right next to Fairfax. Um, Virginia used to have a preemption law, but because of the uh, Democrats taking over the Virginia legislature and the governorship under Ralph Northam, who dressed up in blackface before, they got rid of preemption. And I just want to say that I disagree with that because it allowed different areas to enact their own gun control laws, including Fairfax County, including Loudoun County, where I live. One of the things that Fairfax bans is the carrying of firearms at permitted events and also parks. And we're going to get into what the Fourth Circuit said in this, but first, this case went to a district court level where the district court found that the carrying of firearms in parks is not constitutionally protected. Totally disagree with that. But the banning of carrying firearms at permitted events is constitutionally dubious, and the county cannot do that. So the Fourth Circuit took the appeal on this, and they have come back with a ruling. The first part of the ruling says that parks can ban guns. Now you might want to ask me, well, didn't Bruin says that only specific places can be sensitive areas such as schools and courthouses, but it has to be used very, very sparingly and only in rare occasions. Well, the Fifth Circuit or the Fourth Circuit, sorry, not the Fifth, Fourth Circuit said, well, since we have identified 3 preschools that sit on parks and they looked at over 400 parks, I think 459 parks, and they found 3 that had a preschool. They said that was enough to justify designating all parks as sensitive areas, which is a bunch of bullshit. They looked for a reason to say that the plaintiffs were wrong in that. So they looked and they said these parks, since there's 3 preschools and parks, that all parks have to be considered sensitive areas, and therefore guns are banned in all parks. And there's nothing you can do about that because that is 100% constitutional, which I totally disagree. Now, let's get to the second part. The second part has to do with permitted events. In Fairfax, and you're not allowed to carry a firearm in a permitted event if they post signs to say you're not allowed to carry it. Not only that, but you cannot carry it in adjacent streets. So if you're driving through and you drive by a permanent event, you can be guilty of committing a crime of carrying a firearm in a permanent event. The Fourth Circuit did not rule on the constitutionality of this. The district court did say that that is unconstitutional, but the Fourth Circuit took a different stance on that. Knowing that they would probably fail at a constitutional challenge on this, and there's no way they can do mental gymnastics to get around that challenge, what they said is the plaintiffs lacked standing. Why did they lack standing? a couple things. They said that there was no fear of arrest because they have to post signs near permanent events. Now, they said that the plaintiffs never said that they thought it was unconstitutional to have a sign that says you're not allowed to carry guns and enter a permanent event, even though that should be not this should be obvious. But they said they didn't specifically file for that, so they don't lack standing. So also they said that the plaintiffs didn't identify any type of event that they were planning on going to. So they said the generic saying, "I want to attend permanent events by carrying my guns," isn't enough. You would have to say that this is the events I want to go to. These are the signs that are posted, and I'm still going to carry it. And they're breaking the law, knowing I'm going to get arrested. So they said that the plaintiffs would have to do that. Basically, the plaintiff would have to be arrested before they would have standing, and that's not usually how it works. This was a lot of mental gymnastics to overturn that part, and now, according to the First Circuit, they can ban guns at permanent events and also in parks. It's really, really ridiculous, and I always say that the Fourth Circuit is the most anti-gun state in the anti-gun circuit court in the country, and this is just another example where they ignored certain things and stretched a lot of other things and used legal ways to get out of deciding for the Second Amendment to be able to decide against the Second Amendment. What do you expect from the Fourth Circuit? So that's bad. But it's the Fourth Circuit. Kurt24, member for 2 years on this channel. Thank you so much, Kurt. I really, really appreciate that. But this court case was in front of a 3-judge panel. There's nothing you can really do to help these people. A 3-judge panel is the first step in going to a circuit court. The plaintiffs in the case can go ahead and decide to ask for an en banc. An en banc is when the full bench hears it, so all 16 judges will sit on the court and decide whether or not to take to fine for the plaintiffs or the defendants. They don't have to grant an en banc, and in this case, I don't think it would make a difference because the Fourth Circuit, the en banc is decidedly anti-gun, so that would not help. If I was the attorney for the plaintiffs, I would say we're gonna go ahead and skip that step totally and file for a writ of certiorari to the Supreme Court, because it doesn't really make sense to go to en banc if they're probably gonna rule against you because their history of ruling against the Second Amendment. So by going to the Supreme Court and filing a writ of certiorari, they might actually take this one to clear up the sensitive places issue, because that has been an issue in the past. And the more cases and the more confusion around sensitive places, the better for the Supreme Court to actually take this. If this went to the Supreme Court, I think that the Second Amendment side would win on this issue. It's just a matter of getting it there, because you can file for a writ of certiorari, but cert does not necessarily have to be granted. The Supreme Court can deny cert and kick the can down the road, saying that we're not willing or ready to hear this case yet, and maybe another case will come up soon. But that is it. Just wanted to let you know what is going on in Fairfax and with the sensitive area doctrine. And with that, we are going to get out of here. Thank you so much for watching, and see you guys later.